Minerva Blanchette with a Blanchette law firm, and we're here today to do video number 2 on how to expunge or restrict your record. As we discussed in the prior video, cases for arrests that were occurring before July of 2013, we're now going to discuss with you how to restrict your record on cases for arrests that occurred after that date. And I want to be clear that not all cases can be restricted from your record. Some offenses which you were pled guilty to or you were convicted of cannot be removed or restricted from your record. Those will permanently remain on your record. However, in order for you to determine whether or not you are eligible to have your record restricted or expunged, you're more than welcome to contact our office, and I'll be happy to answer any questions that you have. Our number is 404-997-8470. But today in this video, we're going to discuss how your record is restricted or expunged for arrests that occurred after July 1st of 2013. The law requires now that in order to restrict your record, you do not need to further make application, as we discussed in the first video, for charges before July 1st of 2013. In those Superior Court cases, your record can be restricted at the time that you dispose of the case or the case is disposed of when the clerk of court enters that information into your criminal history. We refer to criminal history in Georgia as the GCIC, which stands for the Georgia Crimes Information Center. They are the ones that are responsible for maintaining your records. Now I want you to understand that even though your record is restricted or expunged from the GCIC, that does not mean that private agencies or private individuals that maintain your record do not have access to the court's records, which are public information, and cannot obtain that information to forward to employers or housing authorities that look to do a background check on your behalf. I will discuss in a separate video how to seal your records, seal those public records so that they cannot be accessed by these private individuals who compile information to provide to these parties. We call those third-party record researchers. In this particular video, I want to explain to you that there are circumstances where your record, even though if it's after July 1st, requires a court order and requires you to file a motion in order to restrict or expunge your record. In certain circumstances that require a court order and require for you to file a motion in that regard would be felony charges that were placed on a dead docket for at least 12 months. If your case was disposed of by it being placed on a dead docket, then you'd have to wait the mandatory 12-month period, and then at that time motion the court to expunge or restrict your record. And it would be in the court's discretion whether or not that would happen. Felony convictions that were vacated by the trial court or reversed by the appellate court can also be expunged or restricted by your record, however, only by motion to the court and by order of the court. Indicted felony charges where there was a conviction only for an unrelated misdemeanor, which means that basically if you had multiple charges, some were felonies and some were misdemeanors, and the court allowed you to plead only to the misdemeanor offenses, then the remaining felonies could be restricted or expunged only by court order and filing a motion. This is some of the information that we'd like to provide to you. If you could call our office, we'd be happy to send you documents or information that would further assist you. We would like to assist you in cleaning your record as well. We are serving northwest Georgia, which includes Bartow County, Cobb County, Paulding County, and we have offices that are located both in Cobb and Bartow County. Our number is 404-997-8470, and again, my name is Minerva Blanchette with the Blanchette law firm. Thank you.